Olivia Carolee Culbreth had consumed alcohol in the early hours of February 9, 2014. Despite having just become a mother 11 days prior at the age of 21, she drove at speeds of up to 100 miles per hour against oncoming traffic on the 57th and 60th highways. This 26-year-old Fontana woman was sentenced to 30 years to life in prison for a wrong-way accident on the 60th freeway that claimed the lives of 6 people. Culbreth's vehicle collided with the Ford Explorer on the westbound road, claiming the lives of 4 individuals in that SUV, including 3 generations of the same family. The 3-vehicle pileup also resulted in the deaths of Culbreth's sister and closest friend, who were passengers in her Camaro. Several California Highway Patrol officers described it as one of the worst wrecks they had ever witnessed. Prosecutors revealed that her blood alcohol concentration was 0.15% 3 hours after the collision. Culbreth had a history of DUI, including a previous collision resulting from impaired driving, as revealed during a preliminary hearing. The court had cautioned her about the dangers of driving under the influence of alcohol and warned her of the potential for serious consequences if such behavior continued. Olivia had a prior DUI conviction and multiple traffic offenses on her record, along with restrictions on her license. When asked about her feelings toward Culbreth, a family member of the victims expressed sympathy, saying, "I don't feel angry. I feel sorry for her, you know. I can't imagine how she'll live with the knowledge of taking so many lives, including her own sister." Olivia was deeply shaken during her sentencing, making emotional statements through tears. She expressed remorse for the lives lost in the tragic accident. Olivia tearfully stated, "I prayed to God every day to console people who have been harmed by this." She emphasized her remorse, expressing her willingness to trade places with the victims if it were possible. "I would die 1,000,000 times over for any one of them," she said, wiping her tears. Olivia acknowledged her wrongdoing, accepting full responsibility for the devastating consequences of her actions. Michelle Lake, who had previously served time for a fatal drunk driving incident, was sentenced to 10 years in prison for causing another collision while intoxicated. The crash occurred at 9:32 a.m. on December 6, 2018. When Lake was driving north on Field Avenue in Westwood, she swerved left of center and collided with an oncoming car, resulting in severe injuries to the driver and front seat passenger. Authorities discovered illegal substances in her system, and her driver's license had been revoked following a previous drunk driving collision in 2006, which resulted in the death of a passenger in her car. Tearfully begging for forgiveness, Michelle Lake faced a judge who expressed sympathy, but labeled her a ticking time bomb. "You're a walking time bomb," the judge stated. "You continue to drive despite not being allowed to do so. You're addicted to heroin and have made no effort to seek treatment over the years. And now, this is the result." Lake struggled to stand as she wept. "I'm truly sorry for what happened," she said after the sentence was handed down. "I wish I could turn back time and relive that day." Michelle Lake, a 35-year-old mother of 3, cannot undo the tragedy of 2018 that left 2 people critically injured. Lake veered over a center line, colliding with Jody Cox's car. Cox shared that her 2-year-old son, who was also in the back seat, thankfully escaped unharmed due to his car seat. "My entire family has been affected," Cox expressed. "This has been a significant financial, mental, and emotional burden on my life and the lives of my family." Prosecutors advocated for the 10-year sentence, citing Lake's prior record and ongoing substance addiction struggles. Lake's blood alcohol content was 0.242, 3 times the legal limit. The judge stuck to the prosecutor's recommendation, sentencing Lake to 8 years in prison for aggravated vehicle assault and an additional 2 years for vehicular assault to be served consecutively. Upon release, Lake will be on probation for 3 years, and her driver's license will be suspended for life. Next on the agenda is the arraignment of 23-year-old Christopher Branham at the Bexar County Courthouse. He's facing charges related to sexually exposing himself and assaulting a young boy in a restroom at a San Antonio movie theater. The incident occurred while the child, his parents, and 4 siblings were attending a movie. He informed his mother about what had happened upon returning from the restroom. Describing the sexual assault of the 7-year-old boy at the Rialto Theater restroom as a parent's worst nightmare, the prosecutor made a strong statement during Christopher Branham's sentencing.
"He is just a sexual predator, Your Honor. He has poor impulse control. He uses drugs, he uses alcohol."
Before receiving his sentence, the defendant had his chance to speak.
I'd just like to say I'm very sorry. If I could take it back, I would.
Branham entered a plea of no contest to the sexual assault charges as part of a plea agreement, which stipulated a maximum sentence of 35 years in prison. In the Santa Barbara County Superior Courts, a man from Santa Maria pleaded guilty to 2 counts related to a tragic collision in North Santa Maria. Javier Cortez, 28, was involved in a collision on March 16th, where his black Chrysler sedan collided with a white Jeep Cherokee carrying 4 passengers. The crash resulted in the loss of 2 lives: Madison Coleman, a 17-year-old resident, and Monica Gonzalez, who was 20. Cortez was suspected of causing the collision after leaving a house party earlier that evening. Cortez faced charges after tests revealed his blood alcohol concentration was over 0.08%, the legal limit for driving. The charges included 3 enhancements: causing serious bodily harm, driving at excessive speeds on a motorway, and having a blood alcohol concentration of over 0.15%. Several local police officers testified about the incident during a preliminary hearing before the judge. Sofia Marquez, a traffic control officer with the SMPD, testified that Cortez had been at a house party on Juleston Drive before the incident. At the party, he reportedly consumed 3 to 4 bottles of beer and tequila jello shots. Before leaving around 2 a.m., officer David Brewer explained that the force of the impact caused a brief flash of light and ejected Gonzalez from the vehicle despite her wearing a seatbelt. Tragically, she did not survive. Another passenger in the Jeep suffered pelvic damage, a fractured arm, and other injuries, requiring airlifting to Santa Barbara Cottage Hospital for surgery. According to California Highway Patrol officers, data retrieved from Chrysler's event data recorder indicated that Cortez was traveling at 104 miles per hour westbound on Donovan Road just 5 seconds before the crash. His speed was recorded at 93 miles per hour in the moments leading up to the collision. During the hearing, Cortez maintained that it was an accident. However, for the individuals affected, the crash took away everything and left them with a lifetime of grief. During Cortez's time on the stand, Julia Coleman, visibly emotional, addressed the court. She described her daughter as a good kid who had a job, a boyfriend, and a 14-year-old sibling and was on the brink of starting college. "We'll never see our child again," she whispered, her gaze fixed on Cortez, who appeared unaffected. Cortez pleaded guilty to homicide and drunk driving, and now faces a sentence of 21 years to life in jail. John Kreischer appeared dejected early in the afternoon in court, later displaying anger at his fate as a registered sex offender.
You know, I sleep in a tool trailer in a damn sleeping bag, you know, because I cannot rent. They won't, every time I find a place that'll rent to the offender, the pro department shoots me down.
In the spring of 2013, John Kreischer had recently moved into a downtown hotel when the San Diego Police Department issued a warning flyer about him. He admitted to being high risk, but he wore an electronic ankle bracelet for tracking purposes and claimed that he wasn't a danger.
I don't jump out of trees from behind bushes, stalk people at night, run around and do anything. I made a mistake.
Kreischer's history included multiple arrests and convictions for sexual crimes dating back to his teenage years. Then, there was another arrest and conviction, this time for attempted sexual battery on a 70-year-old woman. Her daughter, who chose not to reveal her identity, described Kreischer as broken and defective.
"Those are not the acts of a man, Your Honor. That is the behavior of an animal. Were he a rabid pit bull, the county would deal with him expeditiously and ensure that he would never again attack another human."
Kreischer then lashed out at his victim.
Okay, I'm in denial. Do you want to say that? Whatever, but the truth is the truth. And the documentation shows she lied.
Judge Lance Lewis took note of Kreischer's predatory criminal history and handed down a sentence of 25 years to life in prison. The video features a man named Brian Noble. It starts with Judge John Hurley listing off the charges against Noble, who clearly isn't pleased with the amount he's going to owe. Instead of accepting the fines and restraining orders he deserves for threatening the victim, Noble retaliates. He expresses disbelief about the situation, but Judge Hurley stands by the ruling, showing no sympathy towards Noble.
Based on the facts of the case, going after someone with Court finds there is a danger to the victim. Court's going to set count 1 at 10,000. Count 2, court's going to set that bond at 10,000. Court's going to order he has no direct or indirect contact with Jesus Noval. No direct or indirect contact. Must stay 500 feet away from him at all times. I'm going to order that he's not in possession of firearms or ammunition. Court's also going to revoke his bond on 098502 CF10. You're going to be held no bond, sir, until further order of the court. Thank you.
Are you kidding me?
Yeah, no, I'm not kidding you. That's the truth. You're not going anywhere. That's the truth. All right, thanks.
As Brian Noble storms away from the stand, he directs profanity at the judge, prompting him to be quickly escorted back for his misconduct. Being rude in the courtroom is a definite no-no, and Judge Hurley wastes no time holding him accountable.
All right, Suzanne Walt.
My charge was battery.
Oh, wow, I know, man. But that's the way life is. What did he say? Whoa, whoa, whoa. Bring him back. Whoa, whoa, whoa. Bring that guy back. Bring him back. Whoa, 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 whoa. Hey, bring that guy back.
You want him back, Joe?
Yeah, I want him back right now.
That wasn't good, but
Judge Hurley asked Noble to repeat what he said, and Noble openly admitted to his insult. In response, the judge warned him that he could hold him in contempt of court and found him in contempt. Despite a half-hearted apology from Noble for his attitude, it was too late to backtrack. As a result, the judge sentenced him to 60 days in jail.
So what did you just say when you walked away?
I called you a because you're...
Did you?
The charges I had yesterday.
Okay, hold on a second, sir.
Battery charge.
Sir, this court is inclined to hold you in contempt of court, and I want to know from you, give me a reason why I should not hold you in contempt of court.
I don't see a reason why you shouldn't, because there's not a reason.
Brian Noble's attempt at joking about taking back his insult only worsened his case, as the judge again held him in contempt of court. This time, the judge added another 60 days to his sentence, bringing his total time in jail to 120 days. It's clear that keeping his mouth shut would have been a better defense for Noble.
Can I take the back in?
All right, sir, hold it. Come on back. Come on back, sir. Sir, Sir, I'm inclined to hold you in contempt of court again. Would you like to tell me why I should not hold you in contempt of court for the last thing you just said?
I asked if...
So it's going to be 60 plus 60, okay, to run consecutive. Thank you.
After 4 days in jail, Judge Hurley decided to release Brian Noble, believing that he had learned his lesson from his court appearance. The next incident revolves around a 28-year-old man named Joel Guy Jr. On November 26, 2016, in Knoxville, Knox County, Tennessee, he ended the lives of his parents, Joel Guy Sr. and Lisa Guy, shortly after Thanksgiving Day. He repeatedly stabbed them and dismembered their bodies. Following the gruesome act, the FBI, Knox County Sheriff's Office, and East Baton Rouge Sheriff's Office placed Guy Jr. under surveillance for several days before apprehending him. During the trial of Joel Guy Jr., the judge defined the procedures. Everyone present listened attentively, knowing they needed to follow his instructions carefully.
The defendant is presumed innocent and may not be found guilty by you unless, after hearing all the evidence in the case, the attorney's arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The burden of proof remains with the state throughout the trial of the case. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you have an idea what the state's case is about. This opening statement is not evidence. Its only purpose is to help you to understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, an attorney for the defendant may make an opening statement if they should so choose. They do not have to make an opening statement because the defendant has no burden of proof in this case. If they do make an opening statement, I remind you that statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The witnesses will be testifying based upon questions asked by the attorneys. The questions asked by the attorneys are not evidence. Only the responses of the attorneys are considered evidence. And of course, that's in the context of the question that was asked. For instance, if the attorney says the shirt was red, wasn't it? And the witness simply says yes, then you may take that to mean the testimony is that the shirt was in fact red. After the state completes its case in chief, the defense will be given an opportunity to present the evidence, through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you beyond a reasonable doubt the defendant is guilty. If the defense does present proof, the state may then put on what is known as rebuttal proof. And after you hear the state's rebuttal proof, the defense may put on further proof. Once you have heard all the evidence in the case, the parties may present final or closing arguments. Again, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you understand the evidence that was presented and what inferences they wish to draw from that evidence. The final part of the trial occurs when I instruct you on the rules of law that you are to use in reaching your verdict. At that point, I'll excuse the alternate jurors if we still have any left, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. So now that I've described the trial itself in outline form, let me explain the function that you and I perform during the trial. I will decide which rules of law apply to the case, and my decision will be reflected in my responses to questions and objections the attorneys raise, as well as in my final written jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law in my instructions to those facts, and from that application, you will arrive at a verdict. The state has a burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the entire case. The defendant is not required to prove his innocence. You as jurors must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the indictment. You must base that decision only on the evidence in the case and my instructions about the law. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. There is no specific set of guidelines on what you should consider in making that decision. I suggest use common sense first and foremost. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony of the witnesses. Each of you will be allowed to take notes during the trial for your own use during deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. And that's why I provided you those notebooks and pens. If you want to take notes during the trial, you certainly can. You will have those with you during deliberations to refresh your memory. If you don't want to, if you just want to focus on what's being said, you certainly can do that as well. Everybody retains things differently, and I'll leave that up to you to know what works best for you. During the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk to them about any subject whatsoever. You may see them in the hallway, on an elevator, or at some other location. If you do, the best standing rule is not to say anything at all. And that is hard for us in East Tennessee because we are a friendly bunch of folks. And if you see somebody you recognize, you're naturally going to nod, smile, at least say hi. If any of these people see you while this case is going on, they're completely ignore you. If they're walking toward you, they're going to stop and turn and walk away from you. They're certainly not going to say anything to you. They're not even going to make eye contact. Again, please don't be insulted by that. They're not being rude. They're just following my instructions to make sure we keep you folks separate and apart from anyone else throughout this entire process. You also should not discuss this case among yourselves until I instruct you on the law at the end of the case and I'll allow you to begin deliberations. It's important that you wait till you've heard all the evidence in the case before you begin deliberations. And that's another instruction that is difficult to follow because naturally when you take a break, you're going to want to talk with your fellow jurors about maybe a witness you just heard or something that was displayed in evidence. Please do not do that. Don't say anything at all during breaks or lunch or at any point during this trial until deliberations begin with your fellow jurors. Just keep it all in your mind. Once deliberations start, you'll have an opportunity to talk about everything you saw and heard, but don't say anything at all about what's going on during the trial. And that includes not only among yourselves as jurors, but with you and your family and friends.
The prosecutor described the horrific events that happened, highlighting some particularly extraordinary scenarios that occurred during that period.
Article Victims' Rights Act. I can't remember what it is. All right, John, you may begin your opening statement whenever you're ready.
Thank you. Ladies and gentlemen, thank you very much for your time and attention this week. I want to thank you in advance. We expect to prove to you beyond a reasonable doubt that on November the 26th of 2016, Joel Michael Guy Sr. was viciously attacked in his home in the exercise room that he had upstairs. During this assault, he sustained 42 sharp force injuries. You're going to hear proof from the medical examiner and from a forensic anthropologist about these injuries. And what you're going to hear is that these injuries were so severe that marks were left on his ribs, 12 of his ribs, marks ranging from scratches to complete severing. The medical examiner is going to tell you that the cause of his death was multiple sharp force injuries that caused damage to his lungs, to his liver, and to his kidneys. He sustained a wound to his scapula, which is where your shoulder is, and it was such a severe wound that a fragment from a blunt force instrument was left in the muscular tissue next to the bone. He sustained abdominal wounds, so he was attacked from the front as well as the back. Staining evidence in this exercise room that indicated that there was a fierce struggle. In one corner of the room, there is evidence to show that there was thrashing motion, and it left not only marks, but white marks and droplets on two walls of the room, and extensive staining on the carpet. You will hear that he sustained defensive injuries on both of his hands, which indicate that he was fighting, and he fought for his life. And his hands were sliced, and you're going to see photographs and hear testimony about the nature and the extent of these injuries. After he was, the killer disrobed him, meticulously took off his clothes, his shoes, his pants, his shirt and jacket, left them in a heap on the carpet. He left Joel Sr.'s cigarettes on top of the pile. And they were stained. He left his hands in the room. At some point, Lisa Guy came home, and she too was subjected to a violent assault. And you're going to hear testimony and see proof of her injuries. She was stabbed 31 times, and she sustained serious injuries to her ribs. She had 21 rib injuries. 21. 9 of her ribs were severed. And you will hear a forensic anthropologist talk to you about the variation of the injuries to her ribs, indicating not just slice marks, scratches, severing, but also evidence that the sharp instrument used to stab her twisted into the cartilage of her ribs. She had one rib that was fractured from blunt force trauma, not sharp force, but blunt force, indicating that there was pressure applied to her ribs. And you will hear that most of these injuries occurred to her back. She had one injury to her clavicle and a wound, and she had several wounds to her buttock. You will hear testimony that there was evidence in the upper hall at the top of the stairwell from the bottom floor to the top floor that indicates that this is where her murder took place. Blood staining on the walls, drip marks, marks that indicate a spray perhaps. And like Joel Sr., her clothes were removed from her. They were cut off and left in a pile on top of a large blood stain on the carpet. You will hear that the scissors were found there, along with a knife. You will hear that there were also 2 knives left in the exercise room.
Joel's sisters shed light on the dynamics between their parents and brother. It appeared that Joel was deeply angered by a particular decision made by his parents.
I want to direct your attention to the time period around Thanksgiving, just before Thanksgiving of 2016, and ask you if your brother made any statements to you about his future plans regarding the support of his son, Joel Michael.
Yes. My brother had stated to me that he was retiring and moving up, and he had cut his son off from any money, anything. He was tired of keeping him up. And Lisa was fixing to move in the family home, and Lisa was fixing to cut him off when come Christmas when he was supposed to come in. But he came in for Thanksgiving instead.
Okay. Thank you. Pass the witness.
Just very briefly, so I understand your testimony is as to your brother. He stated that he had already cut off his son. Is that right?
Yes.
Okay. And as to your sister-in-law, she told you she was planning to cut him off at Christmas. Is that right?
Yes.
And the conversations that you had, let me ask this, the conversation you had with your brother, was your nephew part of that conversation?
No, he was not there.
Okay. The conversation you had with your sister-in-law, was your nephew a party to that conversation?
Yes. It was all about him off, yes.
Okay. That was a bad question. Let me ask again. When you talked to your sister-in-law about your nephew, did your nephew hear that conversation while it was going on?
No, he wasn't there.
Okay. That's all I was asking. Thank you. One second.
Oh, I'm sorry.
Okay. Just to clarify, as to Ms. Guy, your sister-in-law, did you have a conversation with her yourself, or did your brother tell you about your sister-in-law's plan?
I talked to her about it too.
Okay. And a conversation with her is when she said she was planning to cut him off at Thanksgiving?
Yes.
I mean at Christmas?
At Christmas, yes.
Thank you.
Angela Crane.
Approach Judge.
You solemnly swear or affirm that the testimony about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Let me have a seat. Once you're seated, you may remain with me.
State your name for the record, please.
Angela Crane.
You're going to have to speak up into the microphone.
Sorry, Angela Crane.
Okay, can you pull the microphone close to your... And are you Joel Geis Sr.'s daughter?
Yes.
And you're the defendant's half-sister?
Yes.
And did you have any conversations in shortly before Thanksgiving holiday, shortly before their deaths, about your father's intention to stop providing support for your brother?
Yes.
And what did he say?
He said that Joe Michael was going to be off and going to have to stand on his own 2 feet.
Okay. Did you have any conversations with Lisa Guy about this?
Yes.
And what were those? What did she say to you?
She agreed. It was all in the same conversation with Dad and Lisa.
And this happened close in time to their deaths. Is that correct?
Yes.
Okay. Pass the witness.
Very briefly, Ms. Crane, do you recall when this conversation happened?
Probably October, around the middle, one of my trips back home to Tennessee.
Okay. And I understood you to say this was a single conversation with the two of them.
It's been an ongoing family conversation and knowledge. I know Dad had Joe Michael off probably years before, and the only reason why Lisa ever had a job, because she didn't need to work, was to solely take her check and provide it to Joel Michael, so he didn't need to work.
Okay. The conversation that you had, you said you thought was in October.
Yes.
And in which you repeated statements from both Joel Guy Sr. and Lisa Guy. Just trying to understand, is that a time when there was the three of you talking about it together, or did you talk about it with one and then with the other?
Three of us together.
Okay.
The jurors posed questions to Jennifer, who was Lisa's boss. She hinted at the significant decisions made by Lisa before her tragic demise.
Within that group, we ran payments for Jacobs globally, and she would generate those payment files, review the information within the payment files, and if they were okay to pay, she would go ahead and process those payment batches.
Right. As a full-time employee, did she have benefits with the company?
Yes, she did.
Do you know whether or not she had a life insurance policy?
She did.
And do you know who her beneficiaries were for her life insurance?
I'm not 100% sure what the split was, but it was Joel Sr. and Joel Michael Jr.
Okay. And would you describe it as being work friends? You were friends while you were at work? Is that
correct? Correct.
And as part of your friendship, did Lisa Guy ever express to you her intentions about her future plans for supporting her son?
Whenever we would discuss about her moving to the family home, we did discuss about her intentions with her son.
And what did she say about her future intentions?
About no longer being able to support him because her and Joel Sr. were both retiring.
So you were aware that she was going to move on?
I was aware, yes.
When did she turn in her notice?
She turned in her notice on November 21st, 2016.
Did you discuss her plans to retire before that, though?
Oh, yes, definitely.
All right. And when was her last day at work?
Her last day, per her notice, should have been December 2nd.
And that would have been a Friday?
Correct.
Right. Can you describe her demeanor? Were you able to observe her demeanor during the time prior to Thanksgiving holiday?
Oh, prior to the Thanksgiving holiday, yep. She was excited, yet a little preoccupied because she had so many things changing in her life, but she seemed to be very excited.
Were you aware that she had sold her house?
Yes.
And did you know about her plans for Thanksgiving?
I did.
What did she tell you?
She was excited to know that her entire family, her kids, were coming to spend the holiday with her and Joel Sr.
And did you talk to her at all on the Thanksgiving holiday weekend?
I did not talk to her during the Thanksgiving weekend.
I want to direct your attention to Monday, November the 28th, and ask you what happened that day.
Well, Lisa, her work schedule started at 7 a.m., and I noticed at about 7:15 that she was not in the office. And I normally gave my employees about 15 minutes to get there, and, more out of being concerned that they were okay, I would start calling. So 7:15 came, and she wasn't there. Nobody in her group had heard from her. So I began texting her, and she didn't text back. And I thought that was highly unusual. A lot of thoughts went through my mind, hoping that she was okay, hoping that, this was her last week. She was retiring, that she had blown us off. But I knew that wasn't right. So I continued to text her. I continued to text Joel Sr. I called and never did get an answer.
Would that have been unlike her to not show up for work and not to call?
Oh, absolutely. If she couldn't make it to work, she would have called me immediately.
And do I understand you to say that you also attempted to call her husband?
I did.
All right. And how many times would you say you called or texted?
I lost track of how many times, but I kept doing it thinking this time they're going to answer. I would say at least 20, at least.
And then what did you decide to do?
I wanted to call the police to have a welfare check done. So I called the police.
All right. Your Honor, at this time, we would ask to introduce the first exhibit. Exhibits 1 and 2, a recording of called an emergency line, or non-emergency?
Non-emergency, yes.
Any objections? No. All right, ladies and gentlemen, the court is going to receive this as Exhibit 1 and 2. When I receive an item into evidence as an exhibit, it means it's a piece of evidence that you can consider and will have with you in the jury room during deliberations. 3 and 4. Exhibits 2 and 3. This will be Exhibits 2 and 3. You may publish.
The prosecutors presented various pieces of evidence regarding the brutal incident. Everyone was astonished, and it was a truly terrifying event.
Ballard, about how he responded, knocked on the door, rang the doorbell, went around back, whistled for a dog, again went to the door with no answer. Investigator McCord then received an additional call with more information about Lisa Guy supposed to be at a retirement party, as this was her last working week before she moved to Seguinsville. Some of the things he considered when he got to the residence: he found it odd that the house was for sale and there was no realtor box in the front door. He took that into consideration. He also took into consideration that both the vehicles that were registered to Lisa and Joel Guy Sr. were at the residence and no one was answering the door. He then moves around to the rear of the residence. He finds at the rear of the residence there's a back door with the doorknob absent, a hole instead. And upon investigating that hole in the door, he describes that he could smell chemicals and he could feel heat emitting from where that doorknob should have been. He further described that upon looking at the front door, the doorknob for the front door matched the deadbolt on the back. We saw that ultimately the investigator and accompanying officers were able to gain access into the garage. They were able to open one of the guy's vehicles and hit a garage door opener, which ultimately opened the garage. We heard about what he encountered once he opened that garage. He described that he could still feel heat, he could smell chemicals present in the garage. Ultimately, the officers make a decision based on what they've encountered to make an entry into that residence and conduct a welfare check inside of 11434 Golden View Lane on November the 28th, 2016. And you recall seeing the officers on the body camera with guns drawn based on what they encountered outside. To make sure everyone is okay, they are processing the kitchen, or not processing, but kind of traversing through the varying rooms of the downstairs. At that point, Investigator McCord, if you recall, he said that nothing was really wrong there. There were some odd things I was considering, but nothing showed any signs of struggle. But it was concerning that there were groceries on the floor, the foyer. It was concerning that there were chemicals right when you came in the door. All that changes when they make entry into that stairwell.
Knox County Sheriff's Office! We're here to check your welfare!
And you recall when Investigator McCord testified about the kind of what he was perceiving at the time and how it made him feel based on what he encountered upon making it to the second floor of the residence at 11434 Golden View Lane. He stated, once we get upstairs, it's like the world does a 180. Everything gets turned upside down. He's initially seeing on the way up to the stairs, the doggy gate, and then ultimately a horrific scene, which will later become apparent, the scene where Lisa Guy was executed and subsequently disarticulated. He said he could see straight down the hall, and he saw hands not connected to a body. We also heard that from Officer Ballard, who experienced the same thing, as well as the other deputies who responded on November 26th. With regard to finding the physical bodies, in these tubs right before you, ladies and gentlemen, these 2 tubs, he described that as being gut-wrenching, something he's never experienced before. All the crime scenes that he's responded to, all the homicides that he worked, this one was different. He told us that he will never get those smells out of his head or his dreams. So when we talk about the charges with regard to this case, we'll start with the counts 1 and 2 being the premeditated first degree. Now the judge is going to instruct you as to what the state of Tennessee must prove to you element-wise beyond a reasonable doubt. We have 3 essential elements as it has to do with first-degree murder, premeditated first-degree murder. And those are, we have to prove that Joel Michael Guy unlawfully his father, Joel Michael Sr., and he unlawfully his mother, Lisa Guy, and that in doing so, he acted intentionally, and that the killing was premeditated. The judge will further instruct you as to what the legal definition of premeditation is, and I ask you to consider that premeditation in the legal sense is exercise of reflection and judgment. It's thinking about things, what we're going to do later on in the day, what we're going to wear the next day for work. It's giving something some degree of thought.
The prosecutors presented all the evidence, suggesting Joel had a master plan. The question remains, was he influenced by sinister forces at that time?
Showed you that he acted with premeditation, and we must also establish that he intentionally Lisa Guy, his mother, and Joel Guy Sr., his father. So with regard to Joel Guy Sr., we know that he was executed in the exercise room with apparent signs of struggle. Not only is the exercise machine overturned, but there's a futon present inside that room that has been stabbed. The patterns on the walls, we heard proof about how they had smears in them. There's clearly a struggle in this room. Again, going down the hallway, where Investigator McCord and Ballard were able to see the severed hands in a praying-like position of Joel Guy Sr. So how do we get to that Joel Guy Jr. acted intentionally? What points us there? Well, ladies and gentlemen, we heard from the medical examiner yesterday, and she talked about that she was able to identify at least 42 stab wounds. And there may be more present, but based on the condition of Mr. Guy and the fact that his skin on his front side had essentially dissolved, and he was down to muscle, and portions of his skull had dissolved, she was still able to identify at least 42 stab wounds. And again, when you connect that with the legal definition of acting intentionally, a person acts intentionally when it's their conscious, objective, or desire to cause the death of the alleged victim. Ladies and gentlemen, I submit to you at least 42 stab wounds is acting intentionally. Again, we see that. We see signs of a struggle. We know that in the struggle, Joel Guy Sr. obtained several injuries to himself, either by trying to repel an assault or by physically grabbing the body, knowing that he will be to stop an assault. What does the machine tell us? Points to a struggle. What does the couch or futon tell us? There was a struggle. But most damning, what does Joel Guy Jr. tell us when he goes to Walmart? He tells us there was a struggle. And ladies and gentlemen, you have this video for consideration. It's in evidence. I would ask you to look at his left hand and his inability essentially to use it. Same medical supplies that are ultimately found in the guest bathroom, upstairs level of 11434 Golden View Lane. There's so much of a struggle that Mr. Guy cannot pull his wallet out. If you see his hands, it's evident there was a struggle. Again, with regard to Joel Guy Sr.'s hands, ladies and gentlemen, again, we heard proof yesterday from Dr. Hawes, who established that these are defensive wounds in nature and that they were either obtained trying to repel an assault or grabbing a blade to stop an assault. But further, what did we learn? We learned that when Joel Guy Jr. was arrested in Louisiana, what the video didn't show us is the actual wounds. We got to look at them. We got to see how serious these wounds were. You saw the instruments that were used to Joel Guy Sr., used to stab him at least 42 times, used to create a gaping wound on the left side of his body, used to disarticulate him at the shoulders, at the hips, at the hands. And what was Joel's plan? Joel Guy Jr. Him with the knife. He did, ladies and gentlemen. Consider the torso, what's left of the remains of Joel Guy Sr., who again, previous to this, had been dissolving, essentially, in acidic fluid.
The judge talked a lot about the sentence because Joel messed up seriously.
Community, you consider defense with lengthy criminal histories more closely and take steps to encourage rehabilitative efforts when possible. And since it should exclude all considerations such as race, gender, creed, religion, national origin, and in recognition that prisons are full, then crimes against persons are generally considered more substantial and way more in favor of confinement. And so looking at all that, the court first considers the manner in which these sentences should be served. Obviously, the murders are automatic life sentences. And so the only thing the court has to determine concerning the manner of any of these sentences are the abuse of a corpse charges, and those are Class E felonies. The court does find beyond reasonable doubt that the defendant is in fact a range 1 standard offender because he has no prior felony history. And so the potential range of punishment on each of those counts is 1 to 2 years in prison at a 30% sentencing rate. The court does find that the defendant does not have a long criminal history. It's a clean criminal history, so that does not justify confinement on those counts. Is it necessary to avoid deprecating a serious defense? I do find that factor applies in this case and weighs heavily toward confinement. This wasn't just an abuse of corpse where somebody kills somebody during a robbery, goes out and sets their bodies on fire or tries to bury them. This was the most extreme form of abuse of a corpse I've seen in 25 years. Hopefully it will be the most severe that I've seen in my entire career, however long that lasts. And so I do think that factor alone warrants confinement on the abuse of corpse counts. The others I don't think really apply, other than does he have potential for rehabilitation or treatment. In this particular case, I I don't see any potential rehabilitation in Mr. Guy. I was watching him during the trial. He showed absolutely no remorse or despair at seeing what he had done. Quite frankly, Mr. Guy, you look like you're kind of proud of what you had accomplished. And so I think we could have 500 years to try to rehabilitate Mr. Guy and be unsuccessful. So I think that factor as well weighs toward confinement in those counts as well. Now, as I stated, there's been no argument for enhancement factors, and I don't think any of them would apply. The enhancement factors are merely advisory. The court is not bound to those. It's not like you do some math equation and, well, we got 3 enhancement factors and no mitigation factors, and then you do some type of equation. It doesn't work that way. In this case, just looking at the facts alone, it would warrant a sentence at the top of the range in each of those counts. The mitigation that's been presented really consists of the fact that the defendant has no prior criminal history, which I do find is true in this case. However, I think it's greatly overwhelmed by the evilness of the actions of Mr. Guy in this case. So I do think a sentence at the top of the range in each of the abuse of corpse is warranted, as well as confinement. So the only other question for the court to determine is whether or not these sentences should run consecutive. They're not mandatory consecutive, and so the court has to look at potential discretionary consecutive sentencing. And the one that's been cited is what we refer to as the dangerous offender factor. And not only does the court have to find that a person's a dangerous offender, his behavior indicates little or no regard for human life, which I do in this case. He had no hesitation about committing a crime, which risk of human life is high. In fact, that was his goal in this, was to end human life. You also have to find what we refer to as the Wilkerson factors. And one of those are the circumstances surrounding the commission of the offense aggravated. And so when we look at the counts, I do find that they're aggravated. Mr. Guy was 42 times in his torso, and this guy over 30 times. This was a crime of, I want to say anger, but I'm not sure it was. This was just a crime of just pure evil over. And he was sending a message to his parents and perhaps to his family through his actions. And then the steps that he took to try to dispose of their bodies was beyond anything that would be necessary to form abuse of a corpse. And so I certainly find that the circumstances in this case were aggravated. His confinement for an extended period of time necessary to protect society from the defendant's unwillingness to lead a productive life for the defendant.
Finally, the judge gave out the sentence.
Society, because I don't think Mr. Guy's mind is going to change at any point. And finally, the aggregate length of the sentence is reasonably related to the offense for which the defendant stands convicted. And I am aware that if I give him the maximum sentence and stack it, that he'll be 130 years before he'd be eligible for release. Quite frankly, if it was 300 years, I don't think that would still be sufficient to reasonably relate to the offenses for which he is committed. And so I was thinking, is there any closing remarks I need to make in this thing? And there's not a whole lot for the court to say. The case really speaks for itself. Mr. Guy, I think, thinks he's a lot smarter than he really is. Some of the things he said in this letter that the state has presented, where he's threatening to blind his cellmate so he can get a cell to himself, which not thinking that through any better than he thought through his homicides. And so this is just a pure act of evil, and it was done in a really unintelligent way. And I think that's probably what would bother Mr. Guy the most, me saying he's unintelligent. So, Mr. Guy, at this time, I ask you to stand up. I'm going to sentence you in this remaining count. Joel Michael Guy and Dr. number 110145, the court has already pronounced a life sentence in count number 1. The court is going to merge count number 4 into that life sentence. Count number 2, the court has already entered a life sentence for Lisa Guy, and counts 3 and 5 version of that. I'm going to order that count 2 run consecutive to count number 1. In count number 6, abuse of corpse of Joel Guy, essentially the maximum sentence of 2 years to run consecutive to count number 2, and in count at a 30% sentencing rate. Count number 7, abuse of corpse of Lisa Guy will be the maximum sentence of 2 years and 30% consecutive to count number 6. So it's a total sentence of 2 life sentences consecutive with 4 years stacked on top of that. So you can have a seat now, sir. All right, the next part of the proceedings will be the filing of a motion of new trial. You have an absolute right to an appeal in these matters, and your public defender will remain your attorney for that. I do want to set a status date. Mr. Halstead, I know you may not have the final motion of new trial prepared by our next day, but I want to make sure we keep it on the calendar so we don't lose track of it. How about status on February 5th? That's a Friday.
I'm sorry.
February 5th for status.
Fine.
Motion for new trial.
Yes, Your Honor.
All right, so we'll have a status hearing on February 5th to see how close we are to having the motion for new trial prepared and go forward from there. All right, thank you, folks. Of course, we'll take a recess. We'll come back again in the regular.
Your Honor, one additional thing, he
Yes.
would like to stay here pending the motion for a new trial. I've actually dictated it because I promised him I'd get it done quickly. I've given him part of it. I'm going to give the rest of it to him tomorrow.
I don't have control of that, Mr. Halstead. Once I enter the judgments, he belongs to TDOC. I'm going to enter the judgments today, so I can't tell TDOC they can't come and get him. So they may come and get him, and I have no control over that.
Based on prior discussions, he may end up waiving his right to be brought back. I'll discuss that with him, but we'll do that in writing.
Okay, yeah.
Okay.
Thanks, sir.
Thank you.
Thank you, Your Honor.